of new registrants, so I'm going to go through some of the administration that we normally go through. So if you do have any questions, if you want to put those on the system, and I'll pick those up at the very end. If you're a solicitor, then it's A2 for competency purposes. We will be doing a recording of the webinar, so if you want to have a look at it afterwards, or if you want to share it internally with your staff, then you're more than welcome to do so. I have put the slides, excuse me, on the system, so if you want to have those now, then you can go to the system and get those. And in terms of LinkedIn, well, it's been a really busy few weeks, particularly this week with everything that's been going on. So I've done quite a lot of posts and articles on LinkedIn. So if you want to have a look at those and you want to connect with me, then please do have a look at it. My latest article, which I did yesterday, was whether salaried partners have been set up to fail in terms of them being culps. So you might want to have a look at that and see what you think. In terms of links, they're at the bottom of each slide. So if you want to get more detail, then you can do by going to those. And of course, don't forget to click Save a Seat to register for future webinars. And while we're talking about webinars, our next webinar is next week, and that is our quarterly AML update. So we'll be looking at all the various things that have happened since the last update. So please do come to that one. It's one of our most popular webinars, apart from this one. I just wanted to put it up there, I'm also going to the SRA Compliance Conference on the 21st of October. There's normally around 1,000 people there, so it'll be interesting to network with people and see what issues they're coming across. So if you're going to that, I'll see you there. And then on the 13th of November, we've got Is Your Firm Financially Sustainable? So this will be a joint webinar that we're doing with a finance specialist. And he's working with a lot of law firms at the moment, and he's going to be giving us his thoughts around financial issues and financial stability. So again, if you're interested in coming to that one, just to pick up any useful tips or just to sort of listen to what other people might be having queries with, then do register for that one. So moving on to the main event, and I'm going to spend a little bit of time on this one because this has really caused consternation within the profession. This is the litigation bombshell that we've had, where unqualified employees of law firms can support a solicitor in conducting litigation but cannot conduct litigation under the supervision of a solicitor. So this is the case of Mazur, which has come out very recently. And I'm just going to read a couple of things for you here to try and give you a little bit more clarity around it. So this is a significant decision interpreting the Legal Services Act 2007. And the judge involved in this particular case said that the SRA had wrongly advised a law firm about this. So this is one of the law firms involved here. But it then contradicted its own advice when in court. Now, that, of course, is a big issue for the regulator, and it just, adds to its woes following Axiom and all these other things. So I think the SRA is going to come in for a lot of heat on that one. We've then had, since then, a senior costs judge revealing that the Mazur case has already been cited before him and suggested that legal professional privilege could be a problem when dealing with the argument. So again, things are already being thrown out there into the live world on this one. So make sure you know exactly what's happening there. And then lawyers have been questioning whether the High Court was right in its contentious ruling in Mazur on the conduct of litigation, with the civil procedure rules key in the debate. The issue was also addressed by arguably the leading authority on the regulation of lawyers, Andrew Hopper QC, who unfortunately is no longer with us. He said unauthorized people could conduct litigation. So again, it's going to be interesting because I did some stuff with Andrew, and I know he knows his stuff, and so it will be interesting to see where that one goes. Have we got a judicial review or something else like that sort of coming around the corner? Now, until yesterday, I think it was, or maybe this morning actually, firms were awaiting clear and correct guidance from the various regulators. So I've seen a lot of posts, a lot of blogs criticising SILEC, criticising the SRA, criticising the Law Society for not coming out quickly enough to give guidance to the profession. Well, the SRA has now come out with a statement. Whether it helps you or not, I don't know. But before I just read that, just while I've got it in my mind, conveyancers were getting quite concerned about this one, because obviously there are certain elements of conveyancing that do involve reserved activities. So conveyancers have sort of got into this one, are getting a little bit, well, getting quite worried about it. Whether they will have cause to worry, I'm not quite sure, but this is why we need the regulators to come out, or the courts to come out and basically clarify matters. But here's what the SRA has said. The regulator said the judgment did not change the position in law, that the Legal Services Act makes it clear that only regulated individuals can conduct litigation, as it is a reserved legal activity. Non-authorised individuals can support litigation, as they do in other areas, but only an authorised individual, such as a solicitor, should be conducting litigation. This was not the message provided in the letter to the law firm last December, but it is in line with the guidance issued in 2022. So again, comes back to the SRA giving mixed messages. It added, there is a distinction between conducting litigation and supporting litigation, but the boundary between the two activities will depend on the facts. Being engaged, whether as an employee or other contractor, by an authorised person who is permitted to conduct reserved activities does not automatically confer a right to conduct litigation on an employee or contractor who is not authorised. They are permitted to support litigation under appropriate supervision, but not to conduct it. Our guidance addresses many aspects to consider when assessing appropriate supervision arrangements. The onus is on firms to satisfy themselves that they are complying with the LSA, the Legal Services Act, and only authorised individuals are conducting litigation. We recommend you should be recording your decision-making around the approach you are taking. So they are quite clear here, as usual, that it's for you to make the decision. That is really useful. But clearly, they need to come out and say something to support firms out there that are having real problems at the moment. There's a lot of questions being asked by people who used to be able to do it the other week, and now they can't. And of course, you know, mentioned earlier on, SILEX people. I've seen a number of senior SILEX people who have been doing the job for 35 years and all of a sudden they can't do it. So it really is causing problems in the various firms. So hopefully that gives you a little bit of an insight into it. I have had people sort of contacting me and saying, Brian, you know, what advice are you giving? Well, I can't give advice anyway because we don't have the insurance for that. I can give guidance and things like that. But I think when you have got regulators who don't know what they're up to, and you've got question marks over whether, in fact, the court got it right, it really isn't the time for anyone, really, apart from the courts and the regulators, to be giving guidance. It is a really difficult position, this one, and the sooner the regulators and the courts sort it out, the better. So sorry to start on that one, but I thought that's the one that's been really hitting the mark with firms, and I just wanted to spend a bit of time on that. In terms of the SRA, they have issued a statement on the proposed client account changes. So they're saying our immediate focus is on making changes to better protect and safeguard client money under the current system. We then plan to return to the longer term questions of solicitors holding client money and the compensation fund after we have made changes to the current system, and we can give them the robust consideration they need. This will build on the views and insights we have and will involve working further with those stakeholders. Now, again, this was one I commented on LinkedIn. because my view is this was all just a knee-jerk reaction to Axiom Ints anyway. And one of the questions that I was asking was, well, hang on a minute, prior to Axiom Ints, we had a lot of cases, and you've only got to look at the SDT for this. We had a lot of cases where solicitors were dipping into client account and taking money. So why was it only when 63, 64 million quid went missing from Axiom that it then became a big issue? It's been an issue. Okay, it was a big sum of money, but the issue was still there. So why was it only after Axiom? And as I say, I think this was a knee-jerk reaction from the SRA. I think this is going to go into the very, very long grass. I might be wrong, but I think it is going to go into the long grass, and I'm not sure it's going to come out again. But it depends. We've got a new chief executive of the SRA coming into place in the next month or so. So, and of course, as I said, we've got the SRA conference in a couple of weeks' time. So it's going to be interesting to see what position they take on that. But hopefully that clarifies the position we've got at the moment, so you can sort of tick that one off your list of things to worry about. We've then got draft money laundering regulations. So I discussed this last month, but it's become clearer what impact one of the changes is going to be. So this is around banks. This is looking at client accounts and things like this. So I'm just going to read something for you, because again, this might give you a little bit of more insight into it. So although the changes give banks greater flexibility to consider the risk posed by client account and manage risk accordingly, the policy intent is firms should provide details of the underlying customers to the bank upon request. So you might be getting banks requesting things from you. For example, details of the solicitor's clients. The draft regulations contain a provision that this disclosure would not breach any restriction, however imposed, on the disclosure of information. So they're looking there about the SRA rules on confidentiality, legal professional privilege, and such like. This raises a number of questions for solicitors, in particular whether this will override the trust of the confidentiality of the solicitor-client relationship, and how firms can manage competing duties of legal professional privilege with the duty of disclosure. So again, this is going to be an interesting one to watch. The Law Society has come out challenging this, saying the government changes to the AML rules around pooled client accounts could cause significant and uncertain compliance burdens for law firms. Don't they just love throwing all these mixed messages and burdens and things like that on you? But you know, this is what we've got to put up with. The changes do not enhance the effectiveness of efforts to combat money laundering and went against the government policy of reducing unnecessary and ineffective compliance burdens. And I've, again, said quite a lot about this on LinkedIn, because actually, when you look at the evidence, is there an issue in the legal sector? I think there is a high risk of money laundering in the legal sector if people allow it. But actually, when you look at the evidence, we haven't seen any solicitors, any firms prosecuted for actual money laundering. We haven't seen them prosecuted for facilitating money laundering. So, you know, are we looking at things here which just don't need to be put there because there isn't a problem? So again, you know, I'm going to continue sort of raising that particular question with the relevant authorities. And finally, the provisions relating to the banking sector are so widely drawn that they are likely to have serious unintended consequences for many in the legal profession. Yeah, too right on that one. And so it's going to be for the likes of the Law Society and others to really challenge this and make sure that, you know, we get what is proportionate, not this gold plating where it just isn't necessary. And just something that I picked up just before we came on from an SRA newsletter that they sent out to me. We've obviously had the annual AML survey, and the SRA is saying that around about 280 firms still haven't or didn't respond within the deadline that they had. If you're one of those 280, I would be contacting the SRA ASAP. because I think the next thing will be referrals to enforcement and things like that. But what is going to be interesting, of course, and I've said this over many months, is are we then going to see a new load of cases coming out where people are fined for breaches of the money laundering regulations? Have people given assurances that they have firm-wide risk assessments and all the other things in place when in fact they don't? And in some of the reports I've seen from the SRA recently, they've talked about people sort of having policies dated the day after the SRA sent them a letter and things like that. So they know what people get up to. Just don't be one of those. Okay, our conveyancers also tax advisors. So this is one that's come onto the radar recently as well. So apparently it looks as if SDLT may be covered. And this is even if only to lodge data in the SDLT portal on behalf of clients. Solicitors started to cancel retainers, apparently, rather than accede to client demands for tax advice in the wake of the Angela Rayner stamp duty saga. So this is another one that we need to watch as well. Again, there have been pushbacks in relation to this. So you do need to, watch this space. But I would definitely, if I was a conveyancer, I'd be looking at this one. The other question that there is around this one is, if it does cover conveyancers, we need to be clear as to whether it is the registration of the firm or the individual conveyancers. So that is another one that sort of is hanging out there for clarification. No win, no fee. So this is potentially being talked about as being got rid of. So the SRA looking at things here. So they're looking at clamping down on this. We have seen a lot of this, particularly again around SSB. So we're just waiting for the report on the SSB scandal. So again, this sort of thing has been kicked off by these different scandals. So the regulator will, in fact, it has issued a new warning notice to firms around the use of the phrase and is actively exploring whether more needs to be done in this particular area. And it said, we are concerned the no win, no fee label doesn't give consumers an accurate view of what could be involved when pursuing a claim. The SRA said in a new consultation document, in particular, the risks to the consumer and the potential costs they might incur if a firm doesn't manage a claim appropriately or a claim is unsuccessful. And again, what we saw with the SSB case, or the follow-on from the SSB case, was people having money demanded from them when they thought, well, hang on a minute, this was a no-win, no fee. And therefore, why are you now coming to me for money? So this is where this one's come from. And again, this came out of the notice I received from the SRA this morning. Awab's law is coming into effect on the 27th of October. And this is in relation to housing disrepair claims. And the SRA has put out a warning notice on that. So if you're involved in this type of work, then I would definitely be having a look at what the SRA has put on its website. There's been a rise in SRA reports. Since the start of its financial year on the 1st of November 2024, the SRA has received an average of 1,300 reports per month. That's a cracking number of reports, an increase of 27% on the previous year. It peaked at a record of just over 1,500 received in June, but the SRA also closed a record 1,562 matters. As a consequence, the number of cases being referred for investigation is rising too by 43%, or 236 a month compared to last year. The investigation team is closing 24% more cases as well, to an average of 197 a month. And the SRA's latest performance report showed that just 36% of initial assessments are being completed within 2 months against a target of 80%. And the regulator has a go at you. It was meeting this target until last October before it began to crash. as we can see from those sorts of figures. So the SRA has really got to pull its finger out and sort that out. I have to say, I listened to a number of SDT hearings, and I'm really surprised at how long it takes the SRA to get things through, from sort of the initial investigations all the way through to the SDT. I mean, it could take years. And of course, the mental health that goes around that can be astronomically, problemsome for the individuals. Anyway, OTIOS condition removed. So wanted to just put this one out there. The SDT has removed an OTIOS condition imposed last October on a director of a law firm that prevented him from holding a compliance role. So for those of you who don't know what OTIOS is, it is where something is of no practical purpose or result. And what the SDT said was that the wording of the condition, so this particular individual had a condition placed on them, in requiring him to obtain the SRA's permission to undertake any compliance roles, was OTIOS because he required that permission anyway before becoming a compliance officer. So one of the things was he couldn't be a compliance officer. Having determined that the wording of the restriction rendered it OTIOS, the tribunal found that the restriction was not necessary for the protection of the public or the reputation of the profession. And the reason why this guy decided to appeal this was because he was a conveyancer, and lenders, or at least one lender, had stopped allowing him to do conveyancing work. And because of that restriction that was placed on him, that OTIOS restriction that was placed on him. So these sorts of conditions can have a real impact on, on practitioners. So I think he was right to do what he did. Solicitor took shortcuts. So this is a partner dishonestly assisted in misappropriating a company's funds by turning a blind eye to money laundering issues raised by 3 property transactions. So I suspect this one's going to go before the SRA in due course. There was also his evidence that he never wrote client attendance notes. That's a no-no as far as the SRA is concerned, no attendance notes. We would certainly be picking that up in our file audits that we do for firms. And that although he ticked the box to say that anti-money laundering checks had been carried out, they hadn't been done. And they said, I find therefore that he was knowingly cutting corners in the carrying out of essential checks. And the reason I've put bad apples in, or a bad apple up there, is because I've been looking a lot at bad apples recently. And the question I've been asking is this a bad apple who is just doing their own thing, or is there a wider issue that we've got in terms of, is it the barrel, i.e. the firm, that is basically allowing bad apples to do what they want to do? And I have to say, and again, I've done this on LinkedIn, I've said this before, when you look at a lot of the 100+ firms that have been prosecuted for money laundering breaches over the last couple of years, they all had COLPs, COFFers, MLROs, MLCOs, senior responsible officers for their accreditations. They had the independent audit function, and of course they had all the partners who are joint and severally responsible for compliance. On that basis, that suggests to me that we didn't just have one bad apple in that firm. The whole firm was a bad apple because they just weren't doing things. How is it? Okay, we've got the COLP and things like this, but, we have the independent audit function. Why wasn't the independent audit function picking up the fact that things weren't being done? Why weren't the partners asking the relevant questions as to, well, hang on a minute, why aren't these things being done? So that's why I put the bad apple analogy up there. And we do need to be looking at the wider issues around non-compliance rather than just thinking, oh, it's only one person. A lack of support. So this was an SDT case, dismissed all allegations against a newly qualified solicitor working in a chaotic operational and management structure. And this was one of the cases that I actually watched, where she was not adequately supported. Said the firm was operating a chaotic operational and management structure in which she was not adequately supported as she commenced in practice. There was clear confusion amongst her seniors as to the supervision responsibilities and arrangements which impacted on her work. So it really sends out a message here. You've got to get things sorted out in terms of governance and support, supervision, and all the other things that go with running a business, because it will be the firm that is then taken to task rather than the individual, as we've seen in this particular case. Fake case references. AI is doing a lot of heavy lifting at the moment, but we have had issues again with people using it but not checking it. As I always say now, it's not AI that's the problem, it's the people who take what it produces on face value and without question who are the problem. I use AI on a daily basis, and I am always checking it. And it's a good job I do, because I do find a lot of hallucinations, as they call them, and other errors in the data that it provides. So yes, by all means, get on board the AI train, and a lot of people are, but make sure that what you are actually doing with it is right, that people have had the right training, that you are happy that client confidential information is not going into general forms of AI, so like ChatGPT. The last thing you want to be doing is putting Joe Bloggs' case onto ChatGPT, asking for sort of thoughts on it, and then finding that in future, ChatGPT starts throwing out Joe Bloggs' name as part of the information that it's providing to others. And certainly the SRA is very keen to make sure that people are meeting their confidentiality and privilege requirements. So as I say, AI is not the problem. So this is an Australian solicitor found to have produced cases created by AI for the court, but they've been allowed to remain in the profession. Now, this was, an Australian solicitor, but I wanted to put it up there because I wanted to sort of show perhaps the difference in approach that we have from the different regulators. The Victorian Legal Services Board, the South East States regulator, placed restrictions on the solicitor, but ruled he could still practice as an employee of a law firm under supervision for the next 2 years. Now, many of you may say, well, yeah, that's appropriate. A strike-off is not appropriate for this sort of stuff. But I think we need to be very careful, particularly when you've got the SRA sort of looking at things. They tend to have a different view around enforcement on this stuff and how serious things may be. The sanction followed the solicitor being reported after tendering a list of authorities generated by AI, which included inaccurate citations and summaries. Similar cases have come through the courts in England and Wales, but the consequences have yet to be dealt with by regulators in this country, again, which is why I've sort of put this up here. So the approach of another jurisdiction will be closely monitored as a potential yardstick for penalising this type of misconduct. Placing false material before the court with the intention that the court treats it as genuine may, depending on the person's state of knowledge, amount to a contempt, and that is what might push the sanctioning by the SRA up the ladder. So just make sure everybody is aware of, yes, the benefits of AI, but actually the problems that can come if it's not used properly. FCA registration. So this is, are you complying with FCA requirements in terms of being registered? As if you haven't got your names registered enough all over the place. But this registration covers legal expense insurance, policies for defective title, missing beneficiaries, or warranty and indemnity cover. Among other requirements, you need to be on the Financial Conduct Authority register. The SRA recently found 2 firms which should have been but were not registered. HMRC needs to exclude solicitors from legislation requiring tax advisors who interact with HMRC on behalf of clients to register with it and meet minimum standards. That's what the Law Society has argued. And I think they're arguing that quite rightly, because, the burden on firms is just getting ridiculous. If they're not doing in-depth work around this area, then, do we need all this gold plating? But it's one to look at there. What you don't want is to be found not to have been registered like those two firms when you should have been. Sanctions guidance. So the government has published a guide for businesses and organisations. You need to have a look at these. You need, as I always say in these webinars, to update your firm-wide risk assessment. Now that might be your single firm-wide risk assessment for everything, or it might be that actually you have one for money laundering, you have one for sanctions. I did have a question the other day put to us because somebody had, in effect, had a visit from the SRA, and the SRA said, and where is your proliferation funding firm-wide risk assessment? And of course they said, well, hang on a minute, we didn't know we needed to have one. Well, you don't need to have one, because actually, as long as it's covered in your money laundering one, then that's fine. You can put your sanction stuff in your one single firm-wide risk assessment. So we've gone back and said to the firm, look, just tell them that you've put it in your firm-wide risk assessment under this particular section, and everything is fine. But it just goes to show the SRA really are pushing the boundaries in relation to what they're saying you should and shouldn't have. But make sure that you update your firm-wide risk assessment accordingly, even if that is to say this doesn't apply to us, because again, it's only by doing that the SRA will see that you have read it, you have taken it into account in one way, shape or form. Don't leave yourselves open to the SRA saying, well, there's nothing written down, so as far as we're concerned, you didn't read it, even though it might not have then applied to you. Identity documents. So this is just a reminder, because again, it's come up in different conversations that I've been having and the team have been having. If you have a lot of firms obviously have their sort of list A and their list B of different identity documents, but actually ELSAG now allows a single government issued document such as a driving license to be accepted for both proof of ID and address. And I've always argued this, well, hang on a minute, go into a bank and they ask you for ID. Well, yeah, here's my driving license. I always carry it on me. It's got my name and everything else on it, and it's got my address. And then they turn around and say, no, that's not acceptable. We need to have a utility bill. Well, you don't. Now, you can if you wish. I mean, again, it depends on your risk profiles and all that sort of thing and how you operate. But you don't have to have it. Particularly if you've got Mr. and Mrs. Jones who are sort of just moving from a large house to a small house or whatever. What is the risk? There's not a big risk. So if you just want to use the driving license, then why not? ELSAG says you can. It's a significant step forward and it reduces duplication. So, and it reflects modern living, because the other thing we have to consider is that we now have bank statements and other things like that are online. So could we have more fraud around documents sort of being PDF'd and then changed and things like that? Well, surely if you've got a single government document, like a passport, like a tax bill, like a driving license, well, why don't we use that? So, damages-based agreements. So this is a High Court judge delivered clarity on the operation of damages-based agreements by confirming that if no damages are awarded, no costs can be claimed for legal representation. I've not got sort of further information on that one. What I would suggest is if you go to the link there and you can pick up more on that. I don't know how many of you actually use DBAs, but I suspect it's not going to be that many. But if you want to have a look at it, then please do. Legal Ombudsman descriptions, decisions being published, sorry. They're not naming and shaming. I'm sure this is naming and shaming, but they call it something else. But they have basically said that they're not trying to name and shame errant law firms. Well, why publish it then? But they've published 10 more decisions. You can have a look at those on the link there. This set of 10 decisions highlights recurring errors over missing deadlines or communications issues, such as failing to provide clear and accurate costs information or acting without a client's consent. And we've seen that in a number of cases where claims have been pursued on behalf of clients who haven't given their authority. So I'm not surprised that one's in there. They cover several practice areas, including immigration, conveyancing, family, and litigation. And certainly conveyancing, I hear a lot of things and see a lot of things in the forums that I'm a member of, where conveyancing really has got some work to do to get the confidence of people back, because they're just not communicating with people appropriately, and clients don't like it. Yes, there are clients that are very, very demanding and things like this. We've got to set expectations right at the very beginning, i.e. we are not going to get back to you on an email within X period of time. We will update you. And I was doing a webinar yesterday with some guests, and we were talking about the conveyancing report that we've just published. And we were talking about the issues around the communication. I was talking about silos, and one of the problems that there seems to be is you'll have people in conveyancing firms who sort of handle the file in one particular bit, and then somebody else will handle something else, and then somebody else will handle something else. And the problem is we then lose the communication. People don't think that they need to react as quickly as they should, and that drives a lot of complaints as well. And we see that through the complaints handling that we do in our risk and compliance team. So, make sure that you don't appear on these, and I will say it, name and shame lists, because that's exactly what they are. The Harmon review, okay, I appreciate that the vast majority of you will be law firms. We do have some chambers coming onto the webinar, but I think that the same message has to be there, that, sex discrimination, sexual harassment, and all the other things that sort of are covered in the Harmon review, and there are 36 recommendations. It needs to be looked at by everybody to make sure that people aren't being put under pressure in different ways. And what Harmon said was, the problem is the culture of impunity for those at the top who commit misconduct. Those who are subjected to it feel unable to complain. All the jeopardy is on them. Those in powerful positions, whether at the bar or in the judiciary, who choose to engage in bullying, harassment, or sexual harassment can be pretty confident that nothing will be done about it. And that is what must change. The jeopardy must change from the victim to the perpetrator. And I 100% agree with that. But we are seeing it in the legal sector as a whole, and the SRA clearly is having no time for this. They will go after people, and we've seen cases being pursued in different ways, because obviously there was the Beckwith case, and that didn't turn out very well for the SRA. But there's been others where quite clearly people, have been conducting themselves in a way that they shouldn't have been. So yeah, we've got to have it right from the top. We've got to have the culture right at the very top, and that's got to come through the rest of the firm. And it doesn't matter whether you are a senior partner, the best fee earner in the world, whatever. You cannot allow misconduct of this type or any type to be, to go forward. The moment you allow one person to do it, you then can't hold anybody else accountable, and then you've got anarchy, haven't you? So we do need to be making sure that we are consistent in what we're doing. Transactions down. So again, I put this one up here just to give people a little bit of a feel of the market, but I am seeing so many different reports. It's difficult to understand where things are exactly. We have got issues with the market. Our report says exactly that, but there are buoyant areas as well. So this is, despite the increasing dominance of large firms, they are not the most efficient. And this is what figures say. That's not me saying it. Says the 711 or just over 711,000 completions in the year were still 17% below the levels seen in 2022-23. with Yorkshire and the Humber saw the biggest increase in transactions last year, while the Northeast and Northwest saw falls. So this is from our report, but I am seeing all sorts of things. We can only go by what we're seeing, and our report tends to sort of rely on a lot of conversations with firms. So hopefully we're giving a better picture than a lot of people that are out there. But it is a very moving feast, as they say. This was again one which I picked up this morning. So this is law care. 30% they were saying of people are looking to actually leave because they just feel that their mental health is far more important. That is a real indictment, isn't it, on the profession? 30% looking to leave, and that's in the next year. So we do need to be doing something, because again, one of the things that we need to be putting on risk registers is, well, what happens if we lost 30%? I'm sure all of you on the call, and there will be many not on the call, who do not have issues with mental health problems with their staff, because they look after people, they support people and such like, but there will be some out there. But what would happen if you lost 30% of your staff? What would happen if you lost 5% of your staff? So staffing turnover needs to be part of the risk register. And finally, notable disciplinary cases. So we have our normal sort of tranche of cases that have gone before the SRA, the SDT, but there is one there that I've highlighted in red. So this was the head of a family law team, been fined £1,500 after a tribunal found he ought to have known that an application for a decree nisi had not been lodged with the court. And this was another case that I was watching. And the message is, or the message that was coming from the tribunal was, although he was head of the team and didn't handle such mundane work, as he put it, he was still expected to be aware of what was going on. So again, I wanted to sort of pick up on what I spoke about earlier on in terms of supervision. You can't just turn around and say, well, they're okay, they're getting on with it and things like that. Well, yeah, but you're their supervisor. Are you actually making sure they are doing what they are telling you they are doing? Because certainly in this case, he was relying on people telling him that everything was fine when in fact it wasn't. We have fee earners, we're coming into the practice and certificate renewal season. There will be people who will be telling you that they have done all their CPD, they've done all their competency training and everything else, just for you to be able to tick off, to tell the SRA that everything is fine. That might not be the case. And of course, in terms of CPD competency, the SRA, they are going to be asking for evidence to show that people have done the stuff. And so they'll be putting two and two together, and they'll be saying, well, hang on a minute, here you are saying everybody was competent, but actually they weren't, because they don't have a training plan to show that they did stuff, or they actually didn't do a course on that particular day. So this is all about supervising. It's all about questioning what people are doing. And yes, you might be saying, well, we've got to be able to trust people. Yes, you have, but you've still got to supervise them and ask questions when you think it might be appropriate. And even if that just means a question every now and then, you don't have to be asking them 100% of the time. So review your litigation arrangements in light of Mazur. Support and supervise your staff appropriately. Use AI cautiously and don't take its outputs on face value. Review and update your firm-wide risk assessments and policy controls and procedures. And that's very much, the flavour of the day at the moment. We've got to make notes of what we're up to. So that comes to the end. So we'll move on to questions. And I do have, let's have a look. Jodie, thank you very much indeed. There is a link here, which is the Mazur Russell Speechley's decision. So yes, it's on the SRA's website. So do go and have a look at that. And what I would suggest is just go to the SRA website and use their search facility just put in Mazur, that's spelled M-A-Z-U-R. We've then got Jonathan, who said, who is making these reports? Is it clients suggesting that their solicitor is doing something unlawful, and so it is not a complaint, or is it other solicitors making them? It's a mixture, Jonathan. I mentioned earlier on that I'm a member of a number of different forums and things like that, and I see so many people questioning the conduct of law firms on the other side and things like that. And so I suggest there will be quite a lot of law firms who are reporting other law firms they're dealing with, particularly around undertakings and other conveyancing related matters. Yes, there will be clients, and the SRA will, where appropriate, move it to the legal ombudsman. But of course, they will then look at whether, in fact, there are complaints of misconduct which fall outside the LEO's remit. It could be that actually it's a report coming from the legal ombudsman to the SRA because they've had a complaint from a client, basically suggesting that there is professional misconduct. So, as I say, it could come through all sorts of different routes. Anonymous has said, will Mazur impact other reserved activities? It could, and this is the problem that we've got at the moment. It is very uncertain, and until we get that clarity now, as I did earlier on, I read the statement from the SRA. Whether that has given any sort of help to you guys, I'm not too sure. But certainly, I think it's now for the likes of the Law Society as the representative body to really come out and say, right, this is the position and this is how we move forward with this. These people can do this, these people can't, or actually the court was wrong, we're going to do a judicial review, and therefore hold your horses, we'll come back to you when we can. But somebody definitely needs to pick this one up and run with it until we get the answers that, you know, we need to have. I think one of the other issues is it really shows how much the Legal Services Act 2007 is out of date, and we need to change that. And so whether we've got the political impetus to do that, I'm not quite sure, but certainly myself and the likes of Professor Stephen Mason, you know, things need to change. And this is just in supporting that need for change. So let's see if we've got anything else. Okay, that's great. Yeah, Jennifer was asking for the SRA link. As I say, I would normally have put that on the slides, but that came hot off the press just before we were coming on, and I'd already done the slides and put them on the system. So, as I say, you just need to go to the SRA and pick that up. So there's no more questions there, and I'm aware of time. So I'm going to draw proceedings to a close there. Thank you very much indeed for attending. I hope those of you who have come to this for the first time found it useful. We do these monthly. We've also got our thematic ones monthly. So as I say, we've got the AML update next week, but we are doing others as well. So they're all free. So do come to them, and we look forward to having you come again. So thanks very much. And as always, please do stay safe. Bye-bye.